Hello again, it's Attorney Craig here, and this is One Lawyer's Opinion. Well, we just had another train crash in Philadelphia on Tuesday evening, and this is a situation where the train was traveling at 106 miles per hour as it was entering a turn that was only rated at 50 miles per hour, and the train jumped the tracks, and there was an application of the emergency brakes just moments prior to the crash. It let off the speed from 106 miles per hour down to 102 miles per hour. And today, 2 days later, the train engineer's attorney had come out and said that his client does not recall anything about the accident. But that he is distraught about the loss of life, and our condolences go out to the victims and their families. But we had a similar situation in the Bronx in December of 2013, where a train had been driven at I believe it was 60 miles per hour, and the posted speed, or the allowable speed there, was 30 miles per hour, and that train jumped the tracks and almost went in the water. But there was a loss of life in that accident too, and injuries. And the union representative for that engineer stated that the engineer had a momentary loss of focus of the controls because of being in a temporary daze. So that to me sounds like sleep. But if these train engineers had been determined to have intentionally drove those trains at twice the allowable speed limit for the conditions, then you could make a good case that that was gross negligence, which we know that gross negligence confers a level of intent on the part of the actor, and the responsibility can fall directly on these train engineers if they intentionally drove recklessly, and they may not get the protection of simply being underemployment, and their employer is responsible for paying out these large judgments that we can foresee coming into the future. But simple negligence, such as falling asleep, and it seems like they do not want to admit to falling asleep, but we have a good idea if that's what happened if they don't know what happened themselves. Okay, so but taking the position that they simply were in a daze, or they fell asleep, would be safer, because that would be more of a simple negligence, and the employer would be responsible, and I don't think that there's any intervening act on the part of the employee that would cut off the employer's responsibility there. And even if there was gross negligence on the part of the train engineer, I believe that the employer would still be responsible, but that the train engineer would also bear responsibility, or possibly an insurance company would not allow, there would be an exclusion for intentional act, and wouldn't cover a judgment that would be rendered against the train driver himself. And also this may be against public policy by not allowing there to be some retribution or compensation paid out by an engineer who conducts such a reckless act. So basically my take is, sometimes it's better to claim that you have fallen asleep than to admit that you may have been driving a train at such a reckless speed. Now it looks like the automatic system of maintaining the speeds limitation has not been put into effect in this stretch of track. Many other places around the country there is a system in place that does not allow the train to achieve too great of a speed based on its load and the track conditions and so forth. It looks like the idea is to take away this control of excess of speed away from the engineers, whether that be not allowing them to intentionally speed or to be as a safety backup system perchance they fall asleep. I think it's a good thing, and I think that Congress needs to earmark more dollars to get more systems in place so that things are safer for everybody. But to claim that you've fallen asleep at the wheel does seem to be a more rational move from a legal standpoint on the part of the train engineers, and that's why you're getting that story. That's one lawyer's opinion. What's yours?